Hi all, welcome back to our CMA classes. So let's resume our SARFASI chapter ka remaining portion. Okay. So as I discussed in section 13, what were the measures taken by the secured creditors? We know this now. And I mentioned two of the exceptions, right? What were the 20% wala and the agricultural land wala. So let's continue the other exemptions or exceptions of section 31. Okay, so the provision of this act is not going to apply in certain cases as per section 31. So let's go for a lien on any goods, money, security given by or under the Indian Contract Act 1872 or Sale of Goods Act 1930. So first of all, first thing says about the lien on any goods, okay, or money or securities as per Indian Contract Act or as per Sale of Goods Act, okay, or any other law for the time being in force. This was the very first point. Okay, second, a pledge of movable within the meaning of section 172 of Indian Contract Act. So can I say, let us highlight the main part. Okay, very first was of lien of any goods, money and securities as per Contract Act and Sale of Goods Act or any other law. ठीक है जी. Second is about a pledge of movable things. Okay, and third is about the creation of any security in a craft which is defined under section 2 clause 1st of a craft act 1934. We read like clause 1st and section 2. Okay, then fourth thing comes here, creation of security interest in vessel. Earlier it was of aircraft. Okay, second thing says about the fourth point says about the vessel, and this is as per clause 55 section 3 and merchant as per Merchant Shipping Act 1958. Okay, or and fifth, let's go for the other point, any right of unpaid seller. So let me underline highlight this, unpaid seller, any right of unpaid seller, okay, as per sections 47 of Sale of Goods Act 1930. Any property not liable to attachment excluding the property specifically charged with the debt recoverable under this act or seen under the first provision of this subsection 1 of section 60 of Code of Criminal, and any security interest for securing repayment of financial asset not exceeding 1 lakh. Okay, and these two, as we know about of any security interest created which is related to agricultural land, ESG. And the last is about any case in which the amount due is less than 20% of the principal amount and the interest. So let's make a very quick summary of this section 31 where this is not going to apply. ठीक है जी. First was of lien on any goods, okay, money or securities as per Indian Contract Act or Sale of Goods. Second is about the pledge of movable. Third is about the creation of security which is related to what? The aircraft. Then next was of vessel. जी हाँ. Then any right which is related to what? Unpaid seller. ठीक है जी, हाँ जी. And the property which is not liable to attached. And then the any security for the security repayment of financial asset which is not exceeding 1 lakh rupee. Then the agricultural land wala and 20% wala, which we know. ठीक है जी. So these are the cases where this provision are not going to be applied. Okay ji, let's go for section 5 now. As I told you in the very first lecture of SARFASI, I started from section 13. Okay, now let's go from the beginning. Okay ji, haan ji. Let's go for the section 5 which says about the acquisition of right of interest in the financial asset. Any asset reconstruction company may acquire financial asset of any bank or financial institution. So first of all, here we are talking about the asset reconstruction company. Okay, there is some other sections which is related to, which is saying about the registration of asset reconstruction company and all. Okay, so we'll later on read it, but right now let's go for section 5, which is saying the acquisition of right or interest in the financial asset. So here, any asset reconstruction company which is going to acquire the financial asset of any bank or the financial institution by way of either by way of issuing debenture or by entering into agreement. These are the two ways when they can enter into this process. Okay, but there is one exemption, which is saying any document executed by any bank or financial institution in favor of asset reconstruction company acquiring financial asset for the purpose of asset reconstruction or securitization shall be exempted by what thing? By the stamp duty. Okay, these company need not to, the company, let me read it again, okay, don't get confused here. Any document which is executed by a bank, okay, any documents, we are talking about the documents, okay, of whom, which is executed by bank or any financial institution, okay ji, haan ji, okay, which is in favor of asset reconstruction company which is going to acquire the financial asset for the purpose of asset reconstruction securitization shall be exempted. Okay, they are going to be exempted by what thing? The stamp duty. Okay ji, haan ji, they are going to be exempted from the stamp duty. Okay, hope so this part was clear. In accordance with the provision of section 8F of the Indian Stamp Act, now 1899, but this provision is not going to apply in one case, where the acquisition of financial asset by the asset reconstruction company is for any purpose other than the purpose of asset reconstruction or securitization. Okay, if the main purpose is other than the asset reconstruction or securitization, okay, in that case this exemption will be withdrawn, which means stamp duty is going to be applied. Okay ji, haan ji, let's go for the other part. If on the date of acquisition of financial asset any legal proceeding is pending, what happens usually if any of the cases is pending, then further proceeding cannot be done, right? But in case of this is not going to be applied. Let's read out and understand what is the section saying. If on the date of acquisition of financial asset any legal proceeding is pending by or against the bank or the financial institution, the same shall not be discontinued, right? We have read that in so many sections that if any of the cases is proceeding are pending and all, okay, that would be discontinued, but in this case this will not be discontinued. Okay ji, but such legal proceeding may be continued by or against such company. Okay, so in this section we read about the acquisition of right of interest in financial asset by way of debenture, by issuing the debenture, or by the agreement between the company and the secured, ठीक है, reconstruction company and all, ठीक है जी, okay. And there was one exception which was saying of the documents related to this, ठीक है, stamp duty value was the exemption, but there would be no exemption available if this is not doing for which purpose, the securitization wala purpose, ठीक है जी, हाँ जी, okay जी. And what about the legal proceeding? They will not be discontinued, which means that is going to be continued. Simple है ना, हाँ जी जी. Let's go for section 6 now, ठीक है. This is of notice which is to borrower, okay, borrower, and to discharge of obligation of such borrower. So the bank or the financial institution, ठीक है, may give a notice of acquisition of financial asset, okay, as said by the asset reconstruction company. So the notice is given to 3 people, okay ji, by the bank and the financial institution. Okay, what happens if this notice is not given to them? Okay, there is some cases I'll tell you, but let me say who are the people to whom the notice should be issued. Okay, so there are 3 people: the borrower, the guarantor, and the registering authority. Okay, so the bank or financial institution have to issue the notice to these three people. First of all, borrower, guarantor, and the registering authority. Okay, money received by lender to be held in trust. Okay, what I told you, if the money, if the notice is not issued by the financial institution or bank, in that case what is going to happen? Okay, let's read out now. Where no notice of acquisition of financial asset is given by any bank or financial institution, any money subsequently received by the bank or financial institution shall be constitute money held in trust for the benefit of asset reconstruction company. कुछ समझ में आया? Let me say it again. Okay, as I told you in this section that there is some duty of the bank and financial institution. They have to issue notice to three people. Remember, borrower, guarantor, and तीसरा वाला कौन? Comment below. Okay, registering authority. Okay जी, ठीक है. But what happens if they are not going to issue that notice to these people? Okay, what happens if the money received from the borrower, okay, by the bank and the financial institution, that money, let me read again, that money received by the bank or the financial institution shall constitute money held in a trust. Okay, which is going to constitute a money held for the trust for the benefit of whom? For the benefit of asset reconstruction company. So can I write ARC? ठीक है, so that is going to be constitute for the benefit of ARC. Okay जी हाँ. Duty of borrower to make payment to the asset reconstruction company. So what is going to happen? The bank and financial institution are going to issue notice, right? This we know. Okay, what is going to be written in that notice? Ki you have to discharge your liability, bro. Okay, no, they are not going to say bro. Okay, you have to discharge your liabilities, that's it. But what happens if they are not going to discharge their liabilities? And what happened? They have discharged their liability. Okay, so let's read out. Duty of borrower to make payment to the asset reconstruction company where the notice of acquisition of financial asset is given by bank, financial institution. We know this now. जी हाँ. The borrower on the receipt of such notice, the borrower on receipt of such notice shall make payment to the concern as a reconstruction company. So first of all, once they receive the notice, the borrower receive the notice, they have to repay, right? They have to discharge their liability. We know this. Okay G. Any payment made by the borrower to such company shall give a full discharge to the borrower. ठीक है. Okay, so let's go for the other thing. So this was the section 6 saying to whom it should be issued, right? 3 people. And what if that is not issued? The notice is not issued to the borrower. In that case, the money received is going to be considered what? Comment below, guys. You are not at all active. ठीक है जी. And what are the actions taken by the borrower once they receive the notice? I mean, they have to discharge the liabilities and all. Okay, let's go for section 7, which says about the issue of securities by raising of receipt or fund by the asset reconstruction company. So there is ARC, asset reconstruction company. After acquisition of any financial asset, they are going to offer this security receipt to 2 people. ठीक है. Once, let me say it again, ARC stands for Asset Reconstruction Company. Okay जी, हाँ जी. After acquiring of the financial asset, they are going to offer the security receipt to two people. Okay, first to the qualifying buyers, second other categories of the investors. Okay, so let's read it now. Any asset reconstruction company, ARC, may after acquisition of financial asset as per section 5. Section 5 कौन सा? Let's see it again, guys. Acquisition of right of interest in financial asset by way of two ways, right? Issuing of debentures, right? Agreement between them, remember? Yes, yeah. Exception was there. Stamp duty value, remember? Yes. Okay. And what the legal proceeding which is not going to be discharged, discontinued, right? Okay, everything is clear ना? All clear तो नहीं है ना? नहीं चलो आ जाओ वापस. Okay, so this is saying any ARC may after acquisition of financial asset under section 5. We know this now? Yes, yes, yes. Or security receipt to the qualifying buyers of such other categories of investors, including non-institutional investors, okay, as may be specified by Reserve Bank consultant with the Security Exchange Board of India for the subscription. So this is simply clear, okay, which means ARC after acquiring any financial asset, they are going to offer the security receipt to the qualifying buyers. Okay ji, हाँ जी. Second, to the other investors which are actually specified by the Reserve Bank consultant and the Security Exchange Board of India for subscription. Okay, yes, hope so this point was clear. Let's find out now raising of fund by reconstruction company by formulating scheme. What are the things written in this section? This is any, okay, not and. Any reconstruction company may fund from the qualifying buyer by formulating scheme for acquiring financial asset. Such companies shall keep and maintain a separate district account and respect of each such scheme for every financial asset acquired out of investment made by the qualifying buyers. And third, such company shall ensure that the realization of such financial asset is held and applied to the assumption of investment and payment of short on such investment under the relevant scheme. They are simple. Okay, so we need not to read about this more. But what happens, what are going to be consequences of non-realization of financial asset? Okay, there are some consequences. Let's read out them. In case of non-realization of financial asset qualified by holding not less than 75% of total value of security receipt issued under scheme shall be entitled to meeting of all the qualifying buyers. At such meeting, the qualifying buyers shall follow some procedure as is followed at the meeting of board of directors of such company. Third, there are three times every, there is only one every, okay. Every resolution passed in such meeting shall be binding on such company. Okay, so these are also the very simple things which is written in this section. So let's go for the registration of asset reconstruction company, section 3. Okay ji, and I'll tell you there was question related to this section 3 and section 4. Okay, from past few years I've seen 2 questions, okay, in CMA final. Okay, so let's go for the registration of asset reconstruction company. A reconstruction company shall not commence or carry on business of securitization or asset reconstruction unless the following condition is satisfied. First of all, they have to obtain a certificate of registration. But from whom they have to get that registration? Okay, they have to obtain that registration from which authority? Think about it, comment below. Okay, okay ji, let's continue. It has net fund or not less than 2 crore, which means they should have a net fund of at least 2 crore, okay, or any other higher amount which is prescribed by Reserve Bank of India, which means the first part which I told you, it has to obtain a registration, certificate of registration from RBI. Okay ji, haan ji. Second, net fund of 2 crore or higher amount prescribed by RBI. Okay, let's go for the other condition of grant of certificate of registration. Before granting a certificate of registration, the Reserve Bank shall satisfy itself that the such company has not incurred losses. Let me take out the highlighter. Has not incurred losses in any three. MCQ based question, ठीक है जी, which the company has not incurred the losses in any 3 preceding financial year. First point. Second, that such company has made arrangement for realization of financial asset acquired by it and shall pay the periodic return. This is return, not return. Return and redeem on the respective due dates the investment made in such company by the qualified buyers. So which means they have to realize a financial asset acquired by it. This is the first part, right? Second, in condition they have written that they have to pay the regular return, okay, and redeem the respective dues before the due dates. Okay, let's go for the further point. Direction of such company have educated professional experience in matter related to finance, securitization and reconstruction. Fourth says that no director of such company has been convicted by any offense involving the moral turpitude. Then that is sponsor of asset, this is asset reconstruction company, is fit and proper person in accordance with the criteria as specified by the guidelines issued by RBI. So the sponsor should have specified qualification and all. Okay, ji. Let's go for the further point, that such company has compiled or is in position to comply with the production norms specified by the RBI. So two things similar which is specified by RBI, the guidelines and other things. Okay, such company has compiled with such condition may be specified in guidelines issued by RBI. So in three things they were simply saying which is specified, the guidelines which is specified RBI. Okay, so can I mark it first, second and third? Okay, so hope so this point was clear. So let me read it again for you, that the company have not incurred any loss in past kitna 3 okay, MCQ based question, remember, hanji. And what was the net fund of 2 crore, not less than 2 crore or any of the higher amount which is prescribed by whom? The RBI. Okay ji, hanji. The professional should have professional qualifications ji, and they should make some arrangement of realizing of financial asset. Okay ji, ठीक है. And the director and other employer, the person who are having the power, should not involve in any moral turpitude. Okay, so yes, these are the similar point which is written in this part. Let's go for other thing. Note, in case of substantial change, okay, what is going to happen? Definitely they have to inform the RBI. Okay, what if there is any substantial changes further done by the company, then they have to inform the RBI. Okay, so in case of substantial change, every asset, this is what asset reconstruction company shall obtain prior approval from the Reserve Bank for any substantial change in its management, including appointment of director, all the board of director of the construction company or managing director of the chief executive officer thereof, or change of location of its registered office or changing name. So in this case, first of all, they have to take the prior approval from the RBI, otherwise it's not going to be invalidate, right? Yes. Let's go for the last section of this lecture, okay, which is section 4 of cancellation of certificate. I'll tell you, this was also came in our exam. Okay, so don't think it's easy, it's not going to come. Let's go for section 4. The Reserve Bank may cancel a certificate of registration granted to an asset reconstruction company if such company ceases to carry on business of asset reconstruction. Okay, the company ceases to carry their main purpose, okay, main purpose of doing their business. If they actually seizes that, in that case the RBI is going to cancel their certificate of registration. Simple hai na? Yes. Let's go for the other part. To receive or hold any investment from the qualified buyer, if they are not engaging in this thing to receive or hold any investment from the qualifying buyers, in that case definitely this thing is going to happen. Okay ji, ha. Let's go for the other part. Has failed to comply with any of the conditions subject to which the certificate of registration was granted. Same thing. Okay. The guidelines they are not following, which is given by the RBI. Okay, has failed to comply with the condition required to be fulfilled for the ground of certificate of registration. कौन सा section? Section 3 वाला ना जी. They are not fulfilling the conditions which is written in section 3. Okay, in that case again they have to, what, the RBI is going to cancel their registration. Simple, boss. Let's go for the other part. Fails to comply with any direction issued by the Reserve Bank under the provision of this act. Second, they are not maintaining account. Okay, they are not maintaining account in accordance with the requirement of any law or direction or order issued by RBI. submit or offered for the inspection book. If RBI have asked them to produce any book of accounts, in that case they have not submitted or not produced with the specified time mentioned by the RBI, in that case what is going to happen? Definitely they are going to cancel the registration, right? Ta-da! Yes, let's go for the last point. Or prior approval of Reserve Bank or for any substantial changes. As I told you in this part, the note part, if they are going to make some substantial changes, they have to take the prior approval from whom? The RBI. Okay, hope so this point was also clear. But what happens if the RBI cancel their registration? Can they go for appeal? Do you think so? Think. Yes, but to whom they are going to appeal? Okay, let's go for it. Appeal against the order of cancellation. Asset Reconstruction Company agree by the order of cancellation of certificate of registration may appeal to whom? To the central government. MCQ wala question na? Yes. So the authority is going to be whom? The central government here. Okay. Within how much days? The appeal may be filed within 30 days from the date on which such order of cancellation is communicated to it. Before rejecting an appeal, such company shall give a reasonable opportunity of being heard. It's not hurt, it's heard. Okay, Hanji. And what is going to be the consequences of rejection or cancelling of certificate of registration where the company is already holding an investment? Okay, where the company is actually holding an investment and then cancellation happens. What is going to be happen next? Okay, the asset reconstruction company which is holding investment of qualified buyers and whose application for grant of certificate of registration has been rejected, okay, or certificate of registration has been cancelled. Okay, what I told you in section 3, they for granting registration they have to follow some process and all, ठीक है, right? Net fund वगैरह वगैरह वगैरह. Okay, ठीक है. So if they are not fulfilled, what if the granting of registration is not happened or the cancellation happens? Okay, in both of the cases, okay, we are talking about both of the cases, shall notwithstanding such a rejection or cancellation be deemed to be an asset reconstruction until it repay okay, the entire investment held by it within such period as the Reserve Bank may direct. So which means that the company is holding any investment, okay, and RBI have not granted registration or they have cancelled, the RBI have cancelled their registration. In that case, the company have to repay the investment. Okay, that's it guys. This is going to end of this chapter, but yes, in our module, in CMA module, there is few more topic which is easy, which is quite easy, and it's not going to be take more time. So tomorrow we are going to end this chapter, and after that we are going to start our DT का अलग नया चैप्टर. ठीक है जी, तब तक के लिए what you have to do your revision on consistency. ठीक है, don't give a long break to yourself. Okay, exams are so near. Okay, and many more things we'll talk in our next video. Okay, till then you have to do your revision regularly. That's it. Do your written practice, go for past previous year question papers. Okay, we'll meet in our next video. This is Soumi Santosh. Toodles guys.